Good afternoon and welcome to the Fall MD Anderson Foundation Moot Court Competition. First of all, thank all of you for participating in the competition. Moot Court has always been a very popular endeavor here at Baylor Law School, and we appreciate the work of each of you in making this competition that has unfolded a very fine one. I want to, in particular, thank Professor Mike Berry, who's not here today. Mike prepared the problem. He always does an excellent job in developing a problem that is accessible to first-year students as well as to upper-class students. He fell this weekend, and he has a possible fracture, and at this hour, he is at the orthopedic doctor's office to have him taken a look at. But he asked me to send his regrets. I want to, first off, after mentioning Professor Berry, give our thanks to to Judge Jeff Carrington. Judge Carrington is the United States Magistrate for the Northern District of Texas. He sits in Fort Worth. He is also the president this year of the Baylor Law Alumni Association. Judge Carrington has been much involved in all aspects of the law school for really as long as he's been out as a Baylor lawyer. Also, by the way, his wife, Letty Martinez, is a 20-year plus prosecutor who a couple of years ago went into a criminal defense practice. We are very proud of the Carringtons. I want to thank our officers of the Harvey Ritchie Moot Court Society today, Amanda Ashley Bigby, Reed McKinney, and Brian Shepard. They have, of course, run the competition. It's all gone very smoothly, and we much appreciate the work that you have invested. Professor Greg White has also helped as we've gone forward, giving some assistance to Professor Mike Berry. And our panel today, of course, obviously, in regard to those who will be judging, we have Judge Carrington, and I'll start over here, Professor Jill Lenz, Professor Jim Underwood, Professor Connie Nichols, Professor Luke Meyer, and then the winners of the spring moot court competition, Michael Capero and Jake Fisher. And with that, Judge Carrington, I'll turn it to you.
All right. The Supreme Court of Texas is called to order. The court calls for argument docket number 17-CCDD. It's Max Whiteberry versus Lenzmeyer Motors. Would the counsel for the petitioner make your appearance?
Yes, Your Honor. My name is Sidel Nerthy. My name is Reed Spiller. I'm petitioner 1.
Very good. And for the respondent?
Yes, Your Honor. My name is Andrew Martinez.
Your Honor, my name is David Craig.
Very good. Is the petitioner ready to proceed?
Yes, Your Honor.
All right, you may proceed.
Mr. Chief Justice, and may it please the court. My name is Reed Spiller, and I'm joined by my co-counsel, Sahil Nuruddin, and we represent the petitioner, Max Whiteberry, in this case. We are here today to ask the court to reverse the summary judgment granted by the trial court and affirmed by the Court of Appeals. At this time, I'd like to ask that we reserve up to 4 minutes for rebuttal.
All right, that is granted.
Thank you, Your Honor. There are 2 issues before the court today. I will be addressing the first, and my partner will be addressing the second. The first issue is whether Texas law permits a civil claim for battery without the showing of a harmful contact. And the second issue is if the court finds that a contact is required, whether Max Whiteberry suffered a harmful contact when he had a seizure after viewing a computer video file that displayed flashing lights. Max Whiteberry suffers from photosensitive epilepsy, a condition that can trigger seizures upon exposure to flashing lights in certain patterns and intensities. Michelle Rigby, an employee of Lenzmeyer Motors, was aware of Whiteberry's condition, understood Whiteberry's condition, and intentionally sent Whiteberry a tweet that contained a video file that displayed flashing lights and the word seizure across the screen in the hopes that he would suffer a seizure. The first issue in this case addresses 2 points. The first is the fact that the Texas court's recurring holdings parallel the modernized notion that a plaintiff's injury does not need to result solely from a physical contact in order to prevail on a battery claim. And secondly, if this court finds that a contact is required, what those implications might mean considering the future advancements in modern technology. Texas courts have repeatedly applied the criminal assault statute under the Texas Penal Code in order to sufficiently establish a common law battery claim. Section 22.01 of the Texas Penal Code, the assault statute, states that a person commits the offense if he, 1, intentionally, knowingly, or recklessly causes bodily injury to another, 2, intentionally or knowingly threatens another with imminent bodily injury, or 3, intentionally or knowingly causes physical contact with another when the person knows or should reasonably believe that the other will regard the contact as offensive or provocative.
Now, Counsel, you said that Texas courts have consistently applied this language to civil battery claims, right?
Yes, Your Honor.
Now, did any one of those cases involve the issue of whether or not you had to have a contact?
No, Your Honor, and that's why we're here today.
So was it always dicta in those cases?
Your Honor, they have applied the criminal statute.
They did the criminal statute. Did the facts of those cases give rise to a battery claim either under the common law, the traditional common law, or the statute, so that it didn't make any difference?
Your Honor, they did not state that a contact was not necessary, but under subsection 1 of the criminal statute, there is no contact requirement for a claim.
Okay, one more point for clarification, just so I understand your argument.
Yes, sir.
Are you saying that this provision of the penal code ties this court's hands as to what the elements of battery are in Texas, or just that it's some persuasive authority for what we should do?
Your Honor, I'm not saying that it ties this court's hands. This court may do as they see fit. But this court has in the past applied the Texas Penal Code in order to establish what constitutes a common law battery or assault.
But if we applied the statute this time, it would be contrary to hundreds of years of the common law.
In what sense, Your Honor?
If we interpret the statute and we follow the statute, it can have battery without a contact. That would be inconsistent with hundreds of years of tort law.
Your Honor, it would be, and that's why we think that it should be modernized to reflect the current times and the fact that you can injure another without necessarily making a physical contact in the traditional sense.
So you're asking us to depart from hundreds of years of established tort law?
Your Honor, I'm not necessarily asking you to depart from that. I'm asking this court to continue to use the criminal statute, which this court has done in the past, which does not require that contact element.
Counsel, if the legislature intended to speak to the issue, our hands are tied, right? I mean, we don't have discretion to, if the statute, if the legislature in passing the statute intended for it to have the effect in civil litigation that you claim it has, we have no discretion there, right?
No, Your Honor, this court has adopted the criminal statute in order to determine what is a civil battery in that context. The legislature did not adopt it for the common law. However, the common law has
The
applied.
reason for adopting it is an assumption that the legislature intended it to have this effect in civil
Yes, Your Honor.
litigation, right?
Yes, Your Honor.
So if we come to the conclusion that they intended it to have this effect in civil litigation, at that point, we have no discretion, right? Our hands are tied. So
Yes, Your Honor. Yes, Your Honor.
it has to be one or the other, right? It's either our decision or it's their decision. So what's your argument here? Is it that the legislature intended it to have this effect and thus our hands are tied? Or is it they spoke to a standard and now we're free to adopt it or not?
It is that they spoke to a standard and you are free to adopt that standard, whether this court chooses to do so or not.
How do we even know that they spoke to a standard, though? I mean, did the legislature indicate anything with respect to a potential tort consequence of this statute?
No, Your Honor, they did not.
Then why should I look at it at all?
Because this court has done so in the past for many years. They have applied that criminal statute in order to determine what the elements, the sufficient elements in order for common law battery.
Well, I'm sorry, one more. Have any Texas courts recognized a version of battery based on recklessness?
No, Your Honor, they did not. They have not spoken directly to the recklessness intent requirement, but we believe that it is sufficient. This court has already adopted the recklessness standard to protect individuals from emotional harm.
So that's a modern tort. Battery is a common law. I mean, again, you're asking us to depart from 100 years of tort law, more than hundreds of years of tort law.
Yes, Your Honor. And I believe it would be consistent with what this court has done in the past. This court has adopted the recklessness standard for intentional infliction of emotional distress in 1993 in Twyman v. Twyman, and this court first recognized intentional infliction of emotional distress. And we believe that that is sufficient in order to protect individuals from physical harm. That was done in order to protect individuals from emotional harm that others could intentionally or recklessly bring about. We believe that that should be sufficient in order to protect individuals from potential physical harm.
So are you asking this court to adopt the rule that for any intentional tort claim that recklessness should suffice from now on?
No, Your Honor, I'm not asking this court to do that. I believe
So what if
that
battery
would be
has a
sufficient.
emotional distress, and how would that be different than false imprisonment or trespass?
Well, Your Honor, in the fact that it has stuff in common is the fact that intentional infliction of emotional distress is intentionally or recklessly inflicted for another to suffer emotional harm. Battery is similar in the aspect it is intentionally or could be recklessly inflicted, but it's to suffer physical harm. And we believe that they mirror each other very similarly in that aspect. And we don't think it would be we don't think it would be a stretch. We believe this court is totally justified if they were to adopt a recklessness standard for battery. We're not necessarily asking the court to do that today, but this court is justified in doing so.
So if our hands are not tied, tell us, why is it a good idea for us to do away with the bodily contact requirement?
Your Honor, we don't find that it's necessary. If an individual may act and act with the intent to cause bodily injury to another, objectively verifiable bodily injury to another, we don't believe that that contact element is necessary. And under subsection 3 of the criminal statute, the contact element is still there. And that is where the distinction lies between subsection 1 and subsection 3, in that the contact is required when the conduct is offensive. However, under subsection 1, there is no contact requirement when a person intentionally causes bodily injury to another.
But why?
I'm sorry, Your Honor?
Why have that distinction between parts 1 and 3? And as my fellow justice asked, why should we make that the common law of Texas, getting rid of 200 years of precedent?
Yes, Your Honor, because the offensive contact, there's no objectively verifiable bodily injury. That is...
well, the test for offensive contact is objective.
There's no bodily injury, Your Honor. And that's where the distinctions lie. In subsection 1, there's a bodily injury. Under subsection 3, it's just offensive. And that's where we think this court can draw the line in order to refrain from someone sending a video file and I didn't like what it said, or someone didn't like what it said, they regarded that as offensive. That's where this court is able to draw the line with this criminal statute here, because if it actually causes bodily injury to another, then it should be a battery.
Is it a stretch to, once we get on that slippery slope though, right, I'm offended and my body is offended, or it causes these objectively verifiable repercussions because I'm offended, I'm upset, I'm crying, I can't sleep at night. It's not, you're suggesting it's a bright line distinction between those two, and I'm concerned that it's not.
Yes, Your Honor. In that instance, I would say that would be potentially intentional infliction of emotional distress. That is, mental anguish is not an objective physical harm that can be manifested and can be verified by doctors and experts. And we don't think this court is going to be flooded with claims based upon that. If we hold that distinction there and we require that for there to be an objectively verifiable bodily injury, we don't think that this court needs to make that distinction.
In the negligence context, we refuse to recognize a duty, even though one could be based in a statute, right? So even though there's a criminal statute criminalizing some conduct, that can't be the basis for a duty in a negligence claim. But I'm supposed to take this criminal statute that has no tort consequences at all and let it rewrite the battery claim.
Well, Your Honor, this court has done so in the past. They have used this statute in order to determine whether or not there was a battery. And we believe that this court was totally justified in doing so. We believe that this court should continue to do so in order to protect individuals' rights to be free from harm.
Isn't battery about bodily integrity, though? No. Since when is battery about an actual harm?
Your Honor, we believe that is about bodily integrity. And whenever you can hurt someone through their senses, we believe that that is sufficient to state that that violates their bodily integrity. If you can hurt someone by their eyes or by their ears, by causing deafness, by, if I were to take an air horn and blow it in someone's ear and burst their eardrum, that may not be a contact under the traditional tort law sense, as you're stating, but we believe it would be sufficient here, applying this criminal statute in order to determine what a battery is.
Counsel, this might not be a fair question, and I would have to recheck the record, but you didn't bring a negligence claim here at all?
No, Your Honor. We do not.
So you asked this court to modernize battery law, and I'm assuming that there must be a lot of other state Supreme Courts that have already taken this step.
Your Honor, there are no other states that I'm aware of that have this, that have adopted the criminal statute, as Texas has done so.
My question is, are there any other states that have jettisoned the contact requirement for battery claim?
No, Your Honor, not that I'm aware of. They're not. May I briefly conclude, Your Honor?
You may.
If a person acts intentionally to cause harm to another and is able to do so, we believe that person should be punished. We believe the current state of the law reflects that and should continue to reflect that. We ask the court to reverse the summary judgment. Thank you.
Thank you, sir.
Mr. Chief Justice, and may it please the court, like my co-counsel stated, my name is Sahil Nuruddin, and we are here today petitioning this court to reverse the summary judgment granted by the trial court and affirmed by the Court of Appeals. As technology advances, people are increasingly confronted with a wide range of digital actions that were unanticipated by federal tort law. Digital actions that can cause real-world physical harm. Our client, Mr. Whiteberry, is a living and breathing testament of the harm that can occur because of the digital actions of another. The Court of Appeals incorrectly held that Mr. Whiteberry did not suffer a harmful contact when he viewed the computer video file and subsequently suffered a seizure. My co-counsel addressed the issue on Texas law permitting a claim for civil battery without a showing of harmful contact. However, if some proof of contact is required, then Mr. Whiteberry should still have a viable claim.
How so? What's the contact?
Today I'm hoping to prove to you that first, Mr. Whiteberry was indirectly contacted through social media by Mr. Michelle Rigby, and that his injury was a natural and foreseeable consequence of the events put in motion by Mr. Rigby.
What's the specific contact?
The live video file contacting his eyes, and in turn he having a seizure.
Well, is there any limit to this type of contact? Your co-counsel mentioned a loud noise hurting the ears of someone. Are we getting to where this food tastes bad or it makes me sick and that's an assault and battery, or something's offensive that I've seen and so therefore I feel some type of pain that I want to claim as an assault and battery? Where's the limit?
Your Honor, there are a few cases. Adams v. Commonwealth in Virginia actually has a similar case in that sense where a laser beam was shined in the eyes of a police officer. And they in turn determined that evasive intangible substances such as light or sound or odor are evasive in context of traditional battery law, but they should not preclude an individual from recovering because the person who shined it still did it intentionally in his eye and he suffered irritation and burning sensation in his eyes. And the court determined that to have a sufficient claim, you still needed the intent requirement, which is the hardest element to satisfy. So it wouldn't overburden or create a bunch of cases like you stated of if your stomach hurts from food, the intent requirement still needs to be present. And furthermore,
So under your theory then, anything that is visually offensive to by an objective standard, right, would then be actionable as a battery because light to eyes constitutes bodily contact.
I wouldn't say offensive, Your Honor. I would say if you were to analyze it in the Adams framework and you were to establish those 5 elements and then also the effect on the victim, it can be something, it's not offensive, it was corporeal hurt or physical consequence. So it wasn't just offensiveness to themselves because Marshall Gates did deal with that offensive contact sense, and that's in the state of Texas, the Court of Appeals. And we're able to distinguish that, especially from what we have now, is because in March of AT&T, a woman was wearing a perfume that contacted one of her superiors, and it was a dead dog perfume. I think that's what it would say in the case. And the court said that that's not sufficient for an offensive contact because there was no proof. First of all, there was no proof provided by Marshall that of any injury. And secondly, Marshall had filed frivolous claims previously within the court, so they didn't necessarily. And thirdly, Your Honor, that they didn't want to create a new person-based nuisance theory.
Wait, so we need bodily harm for battery too?
No, Your Honor. I wasn't saying bodily harm. This is the fifth element of battery, which is the injury itself.
Yeah, but you don't need to actually be harmed in a battery claim.
I understand that, Your Honor, and
But you do, I mean, that's what my concern is. This seems really unlimited if it's just offensive contact. Because I could shine a light in your eyes just to annoy you and have I just commit a battery. Because you don't need to be hurt from your battery claim.
Your Honor, I believe that if you were to do that, I understand you don't have to be hurt because that's a sense of nominal damages, and that's how those cases are recognized. But I think that this court, especially with common law battery, has the opportunity today to modernize it and create it in a sense that if someone with specific intent puts something into motion and that causes an injury, a physical manifestation of an injury, that should be sufficient for a battery claim.
Physical manifestation of an injury? What do you mean?
So it's objectively verifiable injury in the sense that what occurred here or what occurred in the Adams case.
Wait, sorry, is that actual harm or what does that mean? I mean, why, if I am trying to shine this light in your eyes, I'm acting for the purpose of doing it, I know I'm doing it, and shine the light in your eyes, why is that not an actual battery in your theory?
I still believe that's an actual battery under common traditional tort law.
So should there be some level of extreme conduct or something that would be a cutoff, so we don't get the car driving toward me with his bright lights on gives me a headache, and therefore I've had a battery.
I mean, Your Honor, in that sense, the headlights, there still needs to be specific intent for causing some harmful or offensive contact.
Let's say I could prove they intentionally turned on their bright lights.
And you suffer a headache.
Yeah.
I don't
Or
believe-
flash those bright lights and all of a sudden I have a seizure.
I would say if they had that sole purpose of intending to cause you harmful or offensive contact, and they're able to satisfy all the other elements of battery, I would not see why that wouldn't be actionless battery.
Well, isn't the intent to do the act, not necessarily to cause the harm?
It's the purpose to contact the individual, is that correct?
So are you arguing that there should be an element of intending the harm?
I believe if the approach, if you do not want to modernize traditional battery law and you were to adopt Adams, the Commonwealth's approach, then that's the approach they would take.
What is that approach?
So the Adams approach states that, like I said, the laser in the police officer's eyes, and they realize that basic intangible substances are hard to come under traditional tort law. So they said that, verbatim, they said the effect on that to prove a touching, the evidence must prove the substance made objectively offensive or forcible contact with the victim's person, resulting in some manifestation of physical consequence or corporeal hurt.
That sounds like the approach your co-counsel was arguing for under the penal code, that we don't require contact, we just require physical injury.
Yes, Your Honor.
So Adams just is the same argument your co-counsel made.
It's the same argument as...
But if we want to insist upon traditional contact, or the traditional requirement of contact, Adams is really not helpful to this court, is it?
No, Your Honor. But if you were to look at previous cases in Texas, especially with Sergeant Fisher and how they modernized...
But it was physical contact official.
Yes, Your Honor. Yes, Your Honor. And that's where the restatement came in and said any unpermitted intentional contact and any subconnection with the body is sufficient for a claim. And comment C under that restatement is a response to Fisher, which says indirect or direct contact with a foreign substance is sufficient. And courts, not necessarily in Texas, have recognized this. The only two cases that we are aware of is Stanton v. Luridge and March v. AT&T. And Stanton v. Luridge was chemical odor emanating from chemicals, and the court never addressed the contact requirement because there was no intent there. But that's why this court today has a unique opportunity to do so and to modernize tort law such that it can provide a remedy.
You know, I'm a little concerned about this whole modern thing that you're suggesting, but because when you're talking about sights and smells being contact,
Yes, Your Honor.
those are not things that we have as much control over. And coupled with your co-counsel's argument that recklessness will suffice, I mean, if I walk into a room smelling bad, I'm probably reckless in causing an offensive contact.
Yes, Your Honor.
Right, or the things that I may do at a football game that may cause someone to have a heart attack when I flip them the bird, an opposing fan. Is that a battery?
Your Honor, with those specific cases, I understand the court's worry of the limitless application that will occur.
I mean, I can control who I hit with my hand, who I fire a weapon at, but people that see me or smell me, do you understand how that's
Yes, Your
different?
Honor. I understand how it could get attenuated in that sense, but other courts have recognized that those sort of substances, when paired up with the other elements of tort law, have been sufficient for a battery claim.
Well, not this court.
I understand that, Your Honor, and that's why it has a unique opportunity today. Because
Yeah,
both.
would we be extending liability for civil action that the criminal statute that you're working with would not find punishable?
Can you?
Yes, so would this offensive smell be criminal?
Hey.
Your Honor, my issue in conjunction with my co-counsel's issue is that if the criminal statute does not apply and you are to stick with common law battery, then this is the avenue you should take. So I'm not saying if you have an offensive smell that would be a criminal case at all. I'm saying that other courts in Kentucky and Georgia have recognized that other intangible substances have been sufficient for a battery claim.
So I guess my concern here is that we would be extending liability far beyond the historical tort battery. And if we're looking at both what this court has said in the past, that the penal statute isn't necessarily an accurate reflection of common law, but rather it's an assault and two forms of battery. We've referenced that this contact is still necessary.
Mm-hmm.
So my question is still, are we going to hold things criminal, since that's what we're basing this case on, and not require a touch or harm that's based upon contact?
I understand your question, Your Honor, and other states have also dealt with that issue, and that's where I referenced Kentucky. And there was a case in Kentucky that an individual, a homeowner, had barns on the property with pigs, and the odor emanating from the swine contacted neighboring individuals, and the court stated that if the individuals, they ended up having respiratory problems and vomiting and physical manifestations of various injuries. And the court recognized that if they were to prove that the intent requirement was there and the other elements of battery were there, that's sufficient. And that was just based off odor. As well as in Dutch v. Shine, the court ruled that x-rays, which you can't see, you can't feel, was sufficient for a physical contact in the sense of a mental anguish case.
Let me ask you to briefly conclude.
Yes, Your Honor. The court before us today has a unique opportunity to follow fellow states and realize the world around us is changing, and with it, the law must adapt. With that, I ask you to reverse the summary judgment granted by the Court of Appeal, granted by the trial court, and affirmed by the Court of Appeals. Thank you, Your Honor.
Thank you, sir. Okay, from the respondent.
Mr. Chief Justice, and Your Honors, and may it please the Court. My name is David Crampton, and I'm here today representing respondent Lenz Meyer Lawyers of Texas Corporation with my co-counsel, Andrew Martinez. This case is before this Court on two questions of law. Are the civil and criminal law the same with respect to battery? And two, is there a contact for the purposes of battery? Is light a contact for the purposes of battery? I will address the first issue, and my co-counsel, Mr. Martinez, will address the second. To understand the first issue, we need to see why the criminal statute does not control for the civil cause of action for battery in Texas. To understand the first issue, we also need to see that the criminal and civil law are separate, that they have different elements, different burdens of proof, and different purposes. To the first point, it's useful to understand why we started citing this statute in 1929 to begin with. Why are we using a criminal statute in a civil cause of action when this court in 1952 in Guy v. Keith said that as a general rule, a criminal statute does not create a civil cause of action absent some express language from the legislature. So from the synthesis of Freedmen's American Law and a Michigan State Law Review article, the state of practice in 1929 in America were one of the largest firms in the country was the New York City Law Office that had 10 lawyers in it. When law school wasn't required, when a bachelor's degree wasn't required, when many people were practicing because they spent 2 years reading the law in an apprenticeship and then stood for an oath of law, and books were hard to get. So this 1929 conduct-oriented criminal statute just so happened to accurately reflect the civil law, common law for battery. And it was a real convenience in 1929. You could cite it, the elements were there, it was one less book you had to buy, and it made life a little easier. And that worked, that convenience existed, because of course, not all errors in trial are reversible error. So you can have something that's maybe not quite right, but doesn't affect the outcome of the case. So in 1973, when the legislature, in crafting criminal law, updated the statute to be results-oriented in part, that convenience fell away. But from the pull of precedent and the way the courts actually treated the cases, changing it didn't make much of a difference. If you look at, especially
The Supreme Court said a couple times though now that, we can use the statute and look at the statute despite all this history.
Yes, Your Honor, that's correct. The key to that, I believe, is in the Watuga case. And if you look at the Watuga case, this court said that A1 corresponds to harmful battery, harmful common law battery. A3 corresponds to offensive, and A2 is essentially common law assault. But the word the court used there, the word this court used, harmful battery, and for A3, offensive battery, where does that come from? Harmful and offensive contact in the traditional elements. If you look at the cases that the dissent cited, and if you'll pardon me, I'll read through, there's about 8 cases. Look at the facts. Contact was always there. This court didn't have to address contact very often.
I'm going to interrupt, because as I understood opposing counsel's argument, it wasn't that our hands are tied and that we are required, right, to adopt this criminal standard for civil law purposes. But essentially what they were saying is it's a good idea, right? Why isn't it a good idea for us to use this criminal standard in our civil law?
Your Honor, we believe that no, it's not a good idea because the criminal and civil law are different. They have different purposes, they have different burdens.
I understand all that. I understand all that. But in terms of the specific standard that has been used here or articulated here by the legislature, what's the problem with applying that in a battery claim?
The problem with applying a battery claim, Your Honor, we believe, is that the tort of battery is a tool that centers around and is grounded in contact. That's reflected in the elements of battery. You ask about the act, the intention to do the act. The third element is the harmful or offensive contact.
It's traditionally been that way, but what's the problem if we turn our back on that tradition?
If this court turns its back on that tradition, we would argue that it actually goes against the real precedent that the court has set. In other words, if you look at the line of cases that this court and the courts below have ruled on with respect to battery contact.
We choose to follow our own precedent, but we can do whatever we want, right? It's our common law. So what's the problem with us turning our back, right, on the bodily contact requirement?
As Your Honor mentioned earlier, the issue is the slippery slope. How do we know, from an administrative standpoint, how do we know when someone's had has a real case, a plaintiff with a real injury or something really happened, versus they're just making it up?
Well, there's still a requirement of bodily injury, though.
I'm sorry,
There's still a requirement under A1 of bodily injury. So
to have a physical harm?
it says intentionally or if they cause bodily injury. So even without contact, there would still be a bodily injury claim.
That's correct, Your Honor. But again, to the purposes of civil law, the purposes of battery allows people to be protected with no harm. As Your Honor pointed out earlier, it's the security of your person, the personal dignity that battery goes to. And to get back and to address what I think Your Honor was.
So would adopting the petitioner's position then require us to turn our back on the idea that there is a battery even without bodily injury, so long as there's bodily contact?
We believe so, Your Honor. It would, in an attempt to protect, honestly, petitioner, Plaintiff Whiteberry, is a sympathetic plaintiff. He had his medical condition used against him by the unauthorized acts of Ms. Rigby when she posted this. What our concern is, while we also have to advocate for our client, we as lawyers also have to advocate for the law and make sure the law works. And so the issue here is that in order to help 3,000 people with this specific type of photosensitive reflex recurring epilepsy, we would turn our backs on the kind of people we've been protecting for the last 400 years when there was no real injury, when it was just their person, their dignity that was affected.
Well, why shouldn't this court seek to have some uniformity between assault and battery under criminal and civil law?
Yes, Your Honor. We believe that the key there is that the civil and criminal law are different. What they seek to protect, what criminal law wants to do, has a moral component to it, and it's about punishment. And it has always been possible to commit a crime without committing a tort, and to commit a tort without committing a crime. The elements that they craft for this criminal actions, they're trying to protect against something specific, and they're trying to punish it, and it's an interest of the state. Notably, under a criminal action for this, Mr. Whiteberry and his attorneys would not be present because it would be an interest of the state, put on by the state, and even if Mr. Whiteberry said he wanted to drop the case, they wouldn't do it because the state has an interest in protecting those kind of people. That comes back to the Adams v. Commonwealth case as well, which from the style of the case is a criminal case with a criminal ruling designed to protect criminal interests, designed to protect against crimes being committed against their citizens. When the gavel falls in the criminal court, you will lose your freedom. Depending on the crime, you may lose your life. And it makes sense that there is a different set of rules that would apply and a different purpose to that. And we would argue that key theme, that criminal and civil law is different, that they have different purposes, different burdens of proof, and different elements is key.
Counselor, if your client walked up to the petitioner and dropped a seizure-inducing pill into his mouth and caused a seizure, that would be a battery, wouldn't it?
Yes, Your Honor, we would analogize that to the Fisher case.
All right. But the difference between a pill and a light is outcome determinative here, right?
No, Your Honor.
And if so, what tort principle is furthered by that distinction?
Yes, Your Honor. We would argue that the complication comes in the use of the internet and in technology, and that there are issues there about how the action was taken, how the harm was created, that don't necessarily fit the tool of battery well.
If the purpose is to compensate injured people, what difference should it make, pill or light?
Yes, Your Honor. The general purpose of tort law is to compensate people, to make them whole, to shift burdens, but that's the purpose of tort law as a whole. That does not fall solely on the shoulders of battery cause of action. We have many different cause of actions that allow people redress for different issues. I think there's something to point out there as well with cause of actions. We don't let people just walk into a courtroom and sign a complaint for any grievance. It has to fit cause of actions because we want that specificity. We want those material elements to be spelled out. And as a result of that, there are naturally going to be some injuries that don't get redressed. Now, that may not be the case here. There may be other causes of action that Mr. Whiteberry has access to. But we think it would be a mistake to put the entire burden of the purpose of tort law on the one cause of action of battery.
It was her the tweet, right? I mean, she's an intentional tortfeasor. She acted for the purpose of actually injuring. How do we deter people like her if contact required?
Yes, Your Honor. I think the key there in deterrence is in the criminal law because she's going to go to jail. She's going to lose her freedom. When that gavel falls in criminal law, they're going to haul you off to jail if that's what the judge said to do, whether you want to go or not. When the gavel falls on the civil side, it's a piece of paper that says
How do we
judge.
compensate the injured party? How do we compensate the injured party? That's the purpose of tort law. So how do we compensate the party for the injuries that they suffered as a result of the intentional behavior of your client?
Yes, Your Honor. We would argue that the remedy would lie in other cause of actions such as intentional infliction of emotional distress, And again,
But
unfortunately.
is this emotional distress? This is a physical manifestation of an injury. He had a seizure.
Yes, Your Honor. While there is a physical injury present, on page 34 of the record, they did plead mental anguish and pain and suffering. The damages for IED would cover lost wages, it would cover medical bills related to that. And so he would be able to be made whole in that cause of action. And again, it goes to the differences between civil and criminal law. Ms. Rigby deserves to be punished. In a criminal court of law, if they accept the facts there as they did here, and they may or may not because it's a different burden of proof, she's going to end up going to jail or suffering whatever the punishment is under that statute, whether they find it to be a misdemeanor or some aggravation.
I know you're thinking though, like we did not bother with tort law at all because criminal law has enough deterrence.
For the deterrence function existing in criminal law, the purpose of the tort law is to make people whole if possible. So while the criminal law would hopefully deter actors like Ms. Rigby from acting in the future, the tort law would be there to attempt to make Mr. Whiteberry whole. But whether it does that under one cause of action or another, it doesn't necessarily mean that battery should bear that entire weight. Because from a desire to compensate a sympathetic plaintiff and to mold the tool of battery into something that it's perhaps not designed to do and hasn't been done over the last 400 years, it might be better off to, as the second restatement authors did, if you look at the section on assault and battery, on section 17, the title of that section is bodily injury without contact. Bodily injury without harmful offensive contact. And if you look at that section, it says see section 46. Section 46 is intentional infliction of emotional distress. Now this court has rightfully limited IED claims because it's difficult to tell if the person bringing the claim really suffered an injury. But that's exactly the same slippery slope we get on if we remove the contact element from battery. The contact element is the glue that has held battery together. That's part of
over the years, you ran us through 1929 and 1973. We're in 2017. The contact may have been the glue in the past, but now in a world with constant change, especially in innovation, why can't the glue be something else?
Your Honor, we wouldn't argue that there isn't a spot here for perhaps the legislature to step in and to take arguments from businesses, from every stakeholder in the state, and to craft a law over the period of a couple of years if fits. But again, the tool of battery, just because you need to dig a hole doesn't necessarily mean a sledgehammer is the right tool for the job. And we would argue that distinction between the civil and the criminal law makes it very dangerous to pull something that was written by the legislature, contemplated for a criminal defense. Perhaps the legislatures knew that the beyond a reasonable doubt burden was there, and they put in language into that assault statute so that people who say beat their wives or their husbands would be more likely to go to jail because they wanted to help prosecutors jump that hurdle. So if we take that language that they may have crafted in a broad sense and rip it down to the preponderance of the evidence standard in a civil trial, we risk exactly the kind of consequences that this court is going to avoid in IIPD. May I briefly conclude?
You may.
Thank you. So because the civil and criminal law are separate, because they have different burdens of proof, different purposes, and different elements, we would ask this court to affirm the ruling of the appeals court below and find for respondent on those issues. Thank you very much.
Thank you, sir.
Mr. Chief Justice, Your Honors, may it please the Court. My name is Andrew Martinez, and I, along with my co-counsel, David Crampton, represent the respondent in this case, Linsmeyer Automotives, a Texas company. We're here today to determine whether this court should expand the definition of contact to include flashing lights displayed from a video file uploaded through social media. I ask that this court affirm the ruling of the Texas Court of Appeals for two reasons. Reason number one, flashing lights don't constitute a contact under Texas civil battery. Reason number two, in a crowded world, a certain amount of contact is inevitable and must be accepted. To my first point, flashing lights don't constitute a contact under civil battery. Even the most liberal cases in Texas, i.e. the Fisher case, as my co-counsel mentioned, requires some physical touching, a junction or union of surfaces. Now, in 1967 in the Fisher case, when it was brought before this court, we expanded the definition to include an object intimately connected with a plaintiff. But the requirement that a physical touching, a junction or union of the surfaces was still maintained. Now, the issue was revisited in 1997 by the Fifth Circuit Court of Appeals in Marshall versus AT&T. And in that case, the court ruled that it's not aware of any particulate touching to form the basis of a contact for battery.
What's the difference between light and smoke?
The difference between light and smoke is that smoke...
For your purposes of battery contact, not generally.
Yes, Your Honor. For the purposes of contact, smoke is a particulate matter, while light is composed of both waves and particles. Now, the reason why that is important is because while smoke particles have certain trajectories and well-defined positions, light waves fill regions of space. Their evolutions in time are not represented by certain trajectories, meaning that it's inherently difficult to guess and predict with any kind of certainty where those light waves will make contact.
Counsel, do you know what a linear accelerator is?
Your Honor, I'm not familiar.
It's a device used in radiation therapy to attack tumors by pinpointing it and shooting radiation at it to kill the cells in the tumor. Now, if I put you under one of these devices and put radiation in the wrong part of your body, I could create a tumor in your body. So, are you saying that that's not battery? That if I intentionally shoot radiation waves at somebody, that that's not a battery? Because under your definition, light not being a contact, which I find dubious given just physics, but I kind of like the way you talk about the pervasiveness of light, but that hypothetical, in some future where we have radiation guns, that's not going to be a battery.
Your Honor, precisely, that is correct. In some future where we have radiation guns, and let's hope to God you're not pointing one at me, that will not constitute a contact because like the radiation waves sent from your tool to my body, sound waves are used to disrupt people's intestines, which was used 2 weeks ago in an attack on the American Embassy in Cuba. And I know that for the purpose of establishing a battery claim, it falls short, but there's legislative action that can be taken for particular tools like the one that you described. And so the inherent difference is, to get back to your question, Your Honor, between light and smoke, is that while smoke is very predictable, has certain mass and certain trajectories, light is a completely different animal. It is reflected, it is refracted, and it involves completely different components which make it inherently difficult to categorize under a 400-year-old claim of battery.
Counsel, doesn't this entire discussion that we're having right here suggest that the whole bodily contact requirement is outdated? I mean, we know too much now, right? Everything at a certain level is physical. And if anything, right, we should just do away with it because it's a line that we can't even draw anymore. And this conversation demonstrates that. Talking about the difference between smoke and light, I don't understand those differences, but it suggests to me that we're drawing a line that can't be maintained.
Respectfully, Your Honor, I would disagree. I would suggest that we've drawn a line in 1967 that we've maintained up to this point, and that it's been there for the purpose of keeping frivolous claims out of this court and out of other courts around the state of Texas. If we erase that line, we are opening up the floodgates of litigation to the slippery slope that my co-counsel had mentioned.
I'm saying there's no line there. We've got to draw a different line.
Your Honor, the line that we have right now is sufficient. If we draw a different line, we're encompassing a number of battery claims that was not intended to protect the bodily integrity from physical contact, a junction or union of surfaces. If we erase the line, everybody in this room is subject to a battery claim because our phones are all talking, our devices are all talking.
Only if it's harmful or offensive.
Your Honor,
only if that was intended.
Your Honor, I'm not disputing the fact of whether it was harmful or offensive, and in particular whether Ms. Wrigley's action was intentional and whether the result was harmful or offensive. But the fact of the matter is, the reason why we have this steadfast line and the reason why it survived all this time is because hurdle number 3, the contact element, has been a hurdle, a steadfast physical component that has been needed to overcome, been needed for plaintiffs to overcome in order to have a valid battery claim.
Well, haven't x-rays been determined to be contact by other courts?
Your Honor, we would argue that x-rays, while determined by other courts to be contact, have been negated in this court because of the physical component of an x-ray is rather an interaction than a contact. There is no physical junction or union of surfaces between an x-ray ray being emitted from whether it's a machine, as Your Honor had mentioned, or whether it's a weapon. It does not make the physical contact that's necessary to satisfy a battery claim.
But isn't intent a check on all this? I mean, if I understood correctly before, light is different than smoke, because light can't be controlled like smoke, and maybe it would bounce off things and batter somebody else. But intent wouldn't be part of it.
Your Honor, while you're correct that intent might not be present, it very well may be. Intent can encompass the purpose to make contact, the knowledge to substantial certainty, and under their proposition, reckless disregard for the fact that our cell phones in this room right now might be making contact with another person, that the light that's reflecting off of the ceiling might be making contact or interacting with the surface of our skin.
Well, in this particular case, Ms. Rigby intended that light to have the outcome that was resolved, right?
Your Honor,
She flashed that light knowing that this plaintiff had a susceptibility to that and would have an epileptic seizure, and that's exactly what occurred, right?
Your Honor, you're completely correct, and respectfully, I would note that the issue today before us is not whether or not she intended to make the contact, but whether or not the contact is sufficient to establish a battery claim.
But it was a contact.
Your Honor, it was an interaction that does not rise to the level of contact for battery.
So what are your arguments for us to refuse to provide a remedy to someone who's been intentionally injured?
Your Honor, our argument is that just like this court and other courts have done in the past, there are legislative avenues to address the weaponizing, as your co-honor mentioned, of tools that can make harmful or offensive results in a plaintiff. And so I would argue, just like in 1998, Congress passed a law against smoking in public areas, this is a matter that should be addressed by the legislature because it's a results-based test that can provide a remedy to a plaintiff that does suffer these harms, as Mr. Whiteberry did. But in this case, battery just is not the right tool. We shouldn't contort a 400-year-old claim of battery to encompass a trivial interaction that was caused by the flashing lights of a video file, flashing lights that are ever present in our world. While our world is developing, the means of communication are solely through electronic devices.
Counsel, I find it ironic that you say that this is a matter for the legislature, and the legislature has spoken and they said you don't need a bodily contact.
Your Honor, while the legislator has spoken to the criminal aspect of battery and assault, as my co-counsel just spent the last 15 minutes mentioning, there is an inherent difference between the criminal and the civil causes of action of battery. And for these purposes...
But you undermine that argument when you say, let the legislature weigh in on this bodily contact question.
Your Honor, not in regards to battery or assault specifically, but in regards to the weaponization of lights, of x-rays, of smoke particles, is a job for the legislature rather than to unnecessarily expand a 400-year-old claim of battery.
You know, for 400 years, we've not deferred to the legislature on this. Right? But in this instance, the Texas legislature has said that your client ought to go to jail for what she did. Why is it such a harsh remedy to also tell your client she should pay the plaintiff's damages? That's much less of a severe sanction than going to jail.
Your Honor, it's not a harsh remedy. It's a remedy that does not fit as a matter of principle under the contact element for battery.
What's the principle that's lacking here?
The physical union or junction of surfaces.
No, that's the legal definition. What's the principle that's missing here that says that your client shouldn't have to pay?
Your Honor, that she does not have a valid remedy or a valid claim of action under battery.
Well, it depends on what we say.
Your Honor, while that is true, this court in particular has spoken in the past twice, only once expanding the definition of contact, and then the second time denying the fact that we're going to expand that definition to include particulate touching, saying that this is more of a civil cause of action akin to a personal nuisance-based theory. And this court denied to do so. And while Adams was mentioned and expanding the definition to include particulate touching, as my co-counsel mentioned, it was a criminal case. And the fact of the matter is they eliminated the need for contact altogether and then looked at a results-oriented, a results-based test. And now we see the effects of that ruling while we're trying to hash out this decision and to figure out whether or not this court should proceed in chasing that avenue, or they should stand steadfast to the fact that that battery maintains a requisite level of physical contact, a union or junction of the surfaces.
Haven't courts made a similar transition though with trespass claims, like as pollution became more common? You know, because the pollution doesn't really touch the land, but, you know, it's still on the land, and if actual damages exist, we allowed that claim to go forward.
Your Honor, while you're correct, the pollution claims that were brought in other jurisdictions were reflective of the particulate touching that we discussed previously. Now, Amphitheaters versus Portland, the Supreme Court of Oregon ruled that light is inherently different than smoke because no one can argue that light is inherently harmful, and that they weren't going to expand this definition to take into effect the infirmity of a claimant of considering whether or not light trespassed to their land or not.
So are you advocating that this court make a rule that excludes light and everything else, no touching is required?
Your Honor, if I understand your question correctly, I'm advocating that this court maintain the contact requirement that there be a physical junction or union of surfaces to satisfy a battery claim. As we see in McCracken versus Sloan, a plaintiff filed a cause of action versus her boss in 1979 while he was smoking a cigar, and the court found that even though the plaintiffs were made nauseous by the smell of this particular plaintiff, the defendant did not commit a battery, stating that it must be questioned whether an individual by his own fiat can erect a glass cage around himself and to declare to all the world that all contact with this person is at the expense of liability. And now while Mr. Whiteberry has had 3 prior episodes, he aggressively engages in social media attacks on Texas businesses, quote-unquote Twitter wars as noted on page 8 of the record, despite his doctor's orders to avoid potential triggering events. And
so he deserved to be battered?
Pardon me?
You're saying the plaintiff deserved to be battered here?
Your Honor, the plaintiff was never battered. He came into contact with light that
he
is a
deserved to
reasonable...
be intentionally injured?
Your Honor, the plaintiff was never intentionally injured under battery. He came into contact with a form of light that was extremely reasonable and foreseeable in this particular circumstance. While he aggressively engages in these Twitter wars and social media attacks on other Texas companies, he's trying to establish the glass cage around himself and say that all contact with this person via light is at the expense of liability.
Just help me, how does it further tort law's compensation and deterrence purposes to deny contact here?
Because it preserves the essential element of a 400-year-old battery claim that there be physical contact. So what it preserves is the integrity of battery itself. While petitioners argue for us to contort it, we ask that this court affirm the holding of the Texas Court of Appeals and rule that flashing lights displayed from a video file do not constitute a contact under battery. Thank you.
All right, I grant 4 minutes of rebuttal.
Yes, Your Honor. Mr. Chief Justice, and may it please the court, there are 2 issues that respondent touched on that I would like to address before the court today. The first, the difference between the civil and the criminal law, and secondly, that this court should rely on the legislature to determine what devices should be sufficient for a battery claim. First, Your Honor, we understand that there are differences between the civil and the criminal law. We understand that. I think everyone understands that. But they often work together and work as 2 separate vehicles for punishing a wrongdoer's single act by punishing or providing a remedy based upon that. And this court has recognized battery and assault as one of those ways. Additionally, if this court was so mistaken in applying the criminal statute for civil battery, I don't think that they would have used the Texas pattern jury charge verbatim for civil assault and battery, verbatim the assault statute from the Texas Penal Code. And the comments following that pattern jury charge state that historically assault and battery were two separate torts, but today the terms are used together interchangeably to refer to conduct defined as assault in the Penal Code.
Counsel, you are aware that the people that put this together were not elected by the citizens of Texas.
Yes, Your Honor, I'm aware of that, and I
They're not
understand that.
lawmakers.
I understand that. I understand it's not binding, Your Honor, but I think that it is highly persuasive, and it does show what this court has relied on in the past in order to sufficiently establish what a common law battery is. Additionally, the fact that this court should rely on the legislature to determine what devices should or shouldn't be considered as devices that could contact an individual, I think it takes away the power from this court, that this court has the power today to determine what is a contact. This court has the power to draw that line, so we don't have to keep going back to the legislature every few months and saying, well, maybe we should adopt this, or maybe we should adopt this advice because this could also be a contact. This court has the power today to determine whether or not contact is even necessary and to determine what constitutes a contact. And lastly, the fact that respondent relied on the criminal statute in order to say that that is how how the victim would be compensated is quite ridiculous, honestly. The fact that the plaintiff would have no way to seek compensation based on the theory that the criminal law alone is sufficient, we totally disagree with, and we think that years of precedent establish that this court disagrees with that as well. And that's why we ask that you reverse the summary judgment granted by the trial court and affirmed by the Court of Appeals. Thank you, Your Honor.
Thank you. All right, this court thanks all counsel for your presentations. We're going to deliberate, and so the court will stand in recess.
Thank you.
Thank you. Please be seated. We lost one justice to soccer. But we still have a quorum, so the court is called to order. It falls to me as the chief judge, presiding judge today, to announce that the winner is the respondents. So congratulations to you. You were all fantastic. It was unanimous in there that we were impressed by all of the speakers. It was not an easy decision, but congratulations to all of you. I'll turn it back over to the dean at this time.
Thank you, Judge. Well, let's congratulate again. Excellent advocacy. You have each made us so proud. You have a wonderful future ahead of you as advocates. I want to thank Ashley and Brian and Reed again for their administration of the competition. And of course, I want to come back and again thank Judge Kiritin for taking the time to come down today from Fort Worth to be with us. And thank you for all you do for the law school on an ongoing basis. Thanks to each of our faculty and student judges. And with that, we are going to recess outside. Reed, do you prefer to do it outside or inside the announcement of the speakers?
I have everyone here already.
Okay, let's do it here. And as soon as we complete the announcements here, we then will recess to the outside and you can continue with the goodies out there. Reed?
All right, we'll start at the top. At number 10, we have Tim Delabar. Then we have a tie at number 8. meet between Sam Scott and Reed Spiller. And then number 7, Lincoln Floyd. I'm sorry if I mispronounce your name, number 6, Fabian Parmar. Number 5, Shay Humphrey. Then 4, Claire Mosley. Now we get the top 3 at Emily Harding. Two, Max Brown. And then without further ado, number 1, our champion, David Crampton. So really, thank y'all all for participation. Lark 3, y'all made this so easy for us. There were no complaints, no problems, no headaches, and we were thrilled for that. Ashley will be taking over next year, and I know she looks forward to working with y'all as barristers and in future competitions. Professor Barry wishes he could be here. Very sad that he's not, and I'm sure he was trying to scream it, but we'll see how that works. You'll get food, you don't want to hear me talk, and y'all stay around for pictures and whatnot. But once again, round of applause for our competitors.